excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoked. Adjourn next week.
Thank you, Your Honor. Alex Warren on behalf of Mr. Hill. Mr. Hill, can you state the court?
Jose Rafael Hill. Good morning.
Good morning. We're going to need to deal with this violation.
Your Honor, I reviewed that with my client. At this time, he's going to admit to not only his behavior towards...
Why was he acting that way? You're going to have to give me an explanation for that. Those folks over there at Community Corrections have to deal with a lot of people coming through, a lot of people that are under stress, and they don't need this garbage. And certainly, and I'll be honest with you, especially Ms. Dozier, does not need this garbage. So before you start talking to me, you better make sure you understand what you're saying to me.
And Honor, before the violation issued, right after the intake terminated because of behavior at the intake, Mr. Hill came to my office.
We're clear. It's not just his behavior. She had to call officers in, try to deal with it, and still tried to do it, and he still didn't do it, and he didn't complete his intake. Go ahead.
My office made me aware of what happened. Sat down with me, wrote an apology letter to Agent Dozier, sent to her. I extended my apologies on his behalf. And I think to try and put this into context, and he acknowledges there's no excuse for it, but to try and put it into context, Mr. Hill has had medication stolen. He's prescribed medication for a mental health diagnosis. As he scheduled 2 appointments with his psychiatrist to make a plan moving forward. And after sending our apology letter to Agent Dozier, one thing Mr. Hill brought up was if his social worker was present at the time of intake, I think that might help him regulate his emotions, but he's still trying to get back on the medication that he's prescribed. So
we'll just read the letter here.
Well, Your Honor, I can answer any of the court's questions, and I think Mr. Hill can answer any of the court's questions as well at this time.
Please, I will answer. Please. Thank you. This is difficult. It's very difficult what's going on. But please, I will answer whatever you need to know from me.
Over here.
I did not expect to go to that meeting and that happen. That's for sure. I'll be open. I'm an open person. And I was just opening up to Ms. Dozier about my...
No, you weren't. You were interfering with the intake process. She was just trying to get certain things done.
Can I mention something?
Go ahead.
I was talking to Ms. Dozier in a meeting, and there was some confusion. I was confused, and I was explaining to her why. Because the magistrate informed me. When I go to community corrections, because he ordered me to go there, and I did everything he told me to do. And when we were in court, when I was in jail, and we were in court, he mentioned about corrections, and I already past experience with community corrections, so I understand that these things cost money. And excuse me, please, I'm not interrupting anyone, and I don't do that. So if I do, sorry. But once I was ordered to go there, I mentioned the judge in court. I said, Judge, I do not have any money. I just do not have any money, Judge. And he said, that's okay. Community corrections will not turn you away if you do not have any money. So when I went to community corrections and met with her in her office, I mentioned that to her. Because she mentioned that, I asked her, is this going to cost me? And she said, yes. And I said, okay, well, I don't have any money. And she mentioned that, excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoked, adjourn next week. Take him.
This exchange shows how a defendant can turn a hearing meant to help him into a bond problem. Hill's attorney came in with a clear plan. He wanted Hill to admit what happened, show that he was sorry through an apology letter, explain the medication issue without using it as an excuse, and offer support such as psychiatric care and a social worker. But Hill kept trying to explain why he acted the way he did. That became a problem because Judge Simpson had already made it clear that the main issue was not just confusion about fees. The bigger concern was whether Hill could follow the community corrections intake process without causing problems or forcing officers to step in. The judge even warned that Hill's attorney was trying to help save his situation. That was an important moment. His attorney seemed to understand that showing remorse and cooperation would help more than arguing about the original confrontation. But Hill continued speaking and then reacted by throwing his hands down. Judge Simpson then revoked his bond and ended the discussion. The big question is whether Hill realized that his own behavior was hurting the strategy his attorney was using to help him. At that point, the hearing was no longer just about his apology. It was about whether he could follow rules and show good judgment in court.
Your Honor, we can come back next week on that.
Yes.
I appreciate that.
Oh, you better keep moving. I'll adjourn this out to the 14th.
Appreciate that, Your Honor.
Here's what I'm going to do, because I think they're going to devote all their resources there, and I don't have everybody in here. Court's going to stay in recess.
All rise. Horrible for everything.
Good morning, Your Honor. James Fifelski on behalf of Benton, who is coming out soon. Please state your name for the judge.
Aaliyah Benson.
All right. Your Honor, this is a new file. I'm asking the court to adjourn for discovery.
Probable cause conference will be adjourned to May 21st, 2026, 9 a.m. Bond continued. Thank you. Oh, go ahead.
Just is present. Today, I'm requesting that the defendant sign some documents as it relates to the current care for her children. So I'm just requesting that the defense counsel review those with her and see if she will sign them, or I will ask or it will be. I hope that would be necessary.
Your Honor, I do have the documents. I don't have a problem discussing those with her. All right. And so I do plan to do that. I did fail to request if I could very briefly address bond. 30 seconds tops.
Go ahead.
Your Honor, she has a $250,000 bond at this point. Her only prior conviction, I believe, is an impaired. She's on bond on a violation of probation with Judge Barr. 5 kids she does need to financially provide for who are under the care of CPS, and there is a family safety plan. I'm just asking that you grant her house arrest so that she can at least work, provide for her children while these cases are pending.
Response.
So I'm going to check bond at this time. This case involves the shooting of the father of the 4-year-old, the defendant's 4-year-old, by her boyfriend, I believe, who has not been found. The defendant did transport the child to the hospital and then proceeded to lie about what happened and then tried to leave the hospital without speaking. So I have concerns that he has a flight risk and danger, given that we don't currently know the whereabouts of who will be her co-defendant. I have additional concerns that she will try to get in touch with him.
Anything else?
GPS tether would help keep track, for Your Honor.
Motion for bond reductions denied. Bond will continue. All right, thank you. I'll be back, Commissioner.
These 2 hearings show an important lesson about bond decisions. A judge can consider what happens in the courtroom when deciding whether someone can follow rules outside the courtroom. In Hill's hearing, His attorney tried to help him by pointing to his apology, mental health treatment, medication issues, and possible support from a social worker. But Judge Simpson focused on what happened during his community corrections intake, including the fact that officers had to get involved. Hill kept interrupting and reacting during the hearing. That made it harder for his attorney to present the calm and controlled case he was trying to build. The result was immediate. Judge Simpson revoked Hill's bond, and the matter was adjourned. Benson's hearing was different. Her attorney asked for house arrest and pointed to her family responsibilities, job, and criminal history. He also suggested GPS monitoring. The prosecution argued against the bond reduction. They raised allegations involving a 4-year-old shooting victim, statements made at the hospital, and concerns about Benson contacting another person who was allegedly involved. Judge Simpson denied the bond reduction and kept the bond at $250,000. Neither ruling means the defendants were found guilty. These hearings were about risk and whether the proposed release conditions were enough to address the court's concerns. The main lesson is simple. Defense attorneys need more than a sympathetic story. They need a release plan that directly answers the judge's concerns. Which argument mattered more to you? The defendant's reasons for asking for leniency or the risks raised by the prosecution? If you found this case shocking, like the video, share your thoughts in the comments, and subscribe for more courtroom breakdowns.